I started getting interested in this subject because I realized all of a sudden that there were 15 states plus the District of Columbia which had passed compassionate use laws either through initiative or constitutional amendment or statutes. And as I began to read about the problems, the land use problems, I mean, I'm a land use guy, there were enormous problems being reported in the paper. I've got a news alert built into my computer, and I get probably 15 to 30 medical marijuana messages a day from news articles of things going on. I said, what is going on here? I went back and looked, and I've given you two things. One is this article just out in the International Municipal Lawyer magazine called Reefer Madness, Land Use and Medical Marijuana. And the other is an outline of a book that Jack Minan from the University of San Diego and I are doing for the ABA on the subject. My focus is principally on the issues of state enabling legislation and local regulation. What do we need to know? What do we need to think about? Well, here's a very typical sort of dispensary. One of the things that's kind of amazing to me that I find that many of the enabling statutes don't even address some of the uses. Colorado, for example, Boulder County, Colorado, has more medical dispensaries than Starbucks and liquor stores combined. But yet the Colorado enabling legislation says nothing about dispensaries. Remember, when you're talking about medical marijuana, there are several activities going on. One is cultivation. Are you able to cultivate the plant? How many can you cultivate? Who gets to cultivate? Then is the distribution problem. How do you get it out to people who have prescriptions? What do you get to possess? What do you get to have yourself, and what do you get to use? And they all have different land use impacts. And I would say that one overarching issue that hasn't been clearly addressed, and one of the reasons why Jack Minan and I decided to do this book, was that there's a tremendous overlap between the business regulation aspects of medical marijuana and the land use aspects. We sometimes ask planning and zoning to do more than it should. And this is one of those areas where that sometimes happens. And you'll see a lot of confusion in the local regulations between what is really a business licensing aspect. Does the operator of a dispensary have a criminal record? What is the intensity of the operation as compared to the land use aspects? Where's an appropriate place for a dispensary? And so forth. And some of them are clearly overlapping. In local regulations, if you're going to get into the business of regulating medical marijuana, we really need to have good purpose and findings at the outset. This is the city of Clare, Michigan, I believe. It's footnoted in the article. And they talk about why they need to do this. And often, as you know, the purpose and findings can be absolutely essential in defending these. Here's another example. This is in San Diego County of purpose and intent. One of the things that we're finding across the board with local medical marijuana regulation is some analogy to sexually oriented businesses. You say, how can that be? Well, those SOBs, as they're sometimes called, have blighting influences on neighborhoods. You wouldn't want to necessarily live next door to a marijuana dispensary, right? Because of the people coming and going. And they have so-called, do you know what they're called in sexually oriented businesses? What we're trying to regulate to prevent? Secondary impacts. Does anybody know what that is? There are increased violence, sexual attacks, rapes, robberies, and other adverse impacts in the immediate neighborhood. There's a clear pattern of increased criminal behavior. Courts in this country have, with regard to sexually oriented businesses, have been willing to allow a municipality to use a study from another municipality as to those secondary effects or secondary impacts in order to regulate the location of sexually oriented business. Now, one important difference, what is a big difference between an SOB and a medical marijuana dispensary or cultivation operation with regard to the standards by which their location is measured? Well, sexually oriented businesses have a gloss of First Amendment protection. Got a fundamental right at stake, the right to communicate. It's at the very edge of the degree of protection that we give to First Amendment speech. It's not pure speech, it's not political speech or religious speech, but it is protected speech And even though it gets very limited protection, it is a First Amendment issue. Medical marijuana, there's no constitutional right to smoke dope. And in fact, when you look at Los Angeles's local regulations, which are probably the most comprehensive, most detailed, you begin to get a sense of what local governments ought to be concerned about when it comes to these dispensaries. There are places where there are large amounts of cash. Los Angeles requires that you have armed, uniformed guards during hours of operation. They even go so far as to dictate the nature of the skylights at these dispensaries so that people can escape in the event of an emergency, but the burglars can't get in because the product is pretty valuable, right? So there are secondary effects, and I think what's interesting to note about both the approach of Clare, Michigan, and other municipalities is the willingness and ability to use these studies on secondary effects. So start with a good, strong statement of purposes, and this is a continuation of San Diego counties. They're concerned here about the intent of the section that the regulations be utilized to preserve the character of neighborhoods, property values, spread of crime, and prevent problems and the like. You can say that all day and night if you want, but you better have some evidence to back it up, substantial evidence. But I believe that courts eventually, when these issues are tried before them, will find that using studies from other municipalities about secondary effects could be a sufficient basis for local regulation. Definitions, and they're really important here. What does it mean to be a dispensary as compared to a grow operation? What does it mean to get paid? Some of the enabling statutes and local regulations under the compassionate use laws don't allow payment. They're compassionate use. But here you need to define consideration, you need to define patient. You need to define where the enabling statute talks about collectives being the only institutions for growing and distributing marijuana. A very thumbnail sketch of the overall issues of planning and regulation for medical marijuana. It's the Wild West right now.